the hearing. I explained to them that I thought it was important that they understood that the state was going to be having to ask for an adjournment of the sentencing because it was inadvertently discovered last week. My assistant noted that she believed that there was a statement and a video from an informant in the jail that was not turned over to the defense, which we all would know could be an appellate issue. So when I spoke to Ms. Gratz about that just yesterday, she even kindly thought, because of what I was referring to, that she already had it, and I was like, oh good, you have it. But then I called my assistant, and she's like, no, this is a different one. So because there's thousands of pages in this case, it was inadvertent. We thought we all had it, but there is this one we didn't have. Then it's complicated because pursuant to the safety concerns that have been expressed by this witness, who is in the state system, in light of what's been out in the media, even issues at Waupun and in the prison system where there's been some safety concerns exhibited, it would be irresponsible for the state to not determine if we have to shade the identity of the person in a video that's on this and possibly garble the voice. It's just certainly something, Your Honor, we can't just rip out. There's a written statement. Our office has redacted that. Ms. Gratz appeared in court and just asked me in between the cases. I'd put on the record, because I'm never going to remember this, that I was in the Sotelo homicide sentencing just previous to this. I didn't have a chance even right now to fully check on the status of the redacted statement, but we can turn the redacted written statement over to the defense right away. That still was, and possibly could have yesterday, but that still didn't solve the issue that there's also this video, and we don't need an appellate issue. In speaking to the defense, that is why they were, in the letter I wrote you yesterday, they were not opposing the adjournment. I think both parties understand there could be some exculpatory information. I know at first blush when I read it, Mr. Prez is alleged to have given this statement. This is not Ms. Burnett giving the statement, but it does sound like he could have made some statements about she didn't know about the homicide portion, but then I explained to Ms. Gratz there was a statement that he said he told her to get rid of all evidence of the homicide. So it's something that the state might argue off of, the defense might argue off of, but either way, we're just looking at this information on the written statement, and as the court is aware, a video statement that's much longer may also not include stuff that could assist the defense. So both parties need to have the opportunity to look more closely at that, and so we need time, Your Honor. So I went out in the hallway and explained to the family, I think there's an aunt that's traveled across the country that, she was sad about this. I told her, I didn't finish telling her, that we'll make every effort in rescheduling this to get a date that works for them in the event any of them can't travel again, that we would, the court does allow things by Zoom, and I believe that the court would allow anybody who wanted to participate, even if that meant making a victim impact statement by Zoom, that they could be able to do that on another date.
Attorney Gratz.
Thank you, Your Honor. That is correct. I became aware of this issue yesterday, and from a legal standpoint, we don't have an objection. My client does want to proceed, though, and I think this, as well as the victim's family, is hard to hear and is not what we want to happen. But I also explained that we want to make sure we're doing it right, and if there is anything that is exculpatory, or I believe the state plans on referencing part of that interview in their argument, I need to review it beforehand, and I do think that having that opportunity is appropriate. My proposal was to have the redacted reports sent to me and then sign a stipulation for the video that I would not turn it over. I don't know if that's enough to satisfy the case law, but I certainly know we do that with a lot of other discovery, so that would be my proposal so that we could get back in court in short order. My client would like to be sentenced as soon as the court is available.
Thank you. We will pick another court date. Reviewing all the case materials is obviously a very fundamental part of the process, and honestly, it's better that it happened now than after the sentencing, because it would have been much more complicated to bring everybody back here if it happened after the sentencing. So let me look at the court calendar and see what can be accommodated.
Your Honor, can we accommodate it till October so I can move back up here with my family, so I can be present for these proceedings?
Are you,
In Las Vegas.
are you with the
I'm sorry
victim?
to interrupt. I'm Braxton's auntie.
Okay, so you're the person that we're talking about that traveled?
Yes,
Okay.
1,900 miles, Your Honor, so I can be heard. I want to be heard. I want to honor my nephew.
Friday, October 11th at 2 o'clock.
I'll be here with bells on.
Okay. Yeah, no more comments from the gallery, thank you.
I'm not available October 11th, but we were hoping for a date substantially sooner. I mean, people can appear by Zoom. I think that with the technology, we're able to accommodate a lot of different appearances.
But the bottom line is October 11th, you're not available?
Correct.
Okay. What about Friday, October 4th at 2 o'clock?
That would work.
And the court's calendar for July and August is going to be pretty full, especially if it's going to be a testimonial, victim impact statement, sentencing
And it
hearing.
is contested. I don't think we're close on our recommendations here.
Okay. So I even if I did move it up sooner, it would only be a couple weeks sooner into mid-September. So I think I'm going to accommodate the request to have it in early October. But I said 2 o'clock, I think, October 4th?
Correct.
Okay. Friday, October 4th at 2 o'clock. Anything else, Attorney Grotz?
Yes, my client would ask the court to consider a bond modification then. The PSI recommendation is for probation. She's been in custody for over a year now. She entered pleas in April. I think she should be given the opportunity to be released even on electronic monitoring to get home to her daughter and her family who have been taking care of her daughter and need her.
I've outlined to Ms. Grotz several other cases where people with no prior records, the state will be recommending sentence consistent with that. We've seen them getting between 6 to 10 years. I see those are people in a very similar situation with aiding on cases, as I indicated to Ms. Grotz.